My name is Jeremy Rowe. I'm the chairman of Bully Banks. Today's video update is on the subject of Ian Parker's case against NatWest and RBS. We've had the decision today, and unfortunately the decision is in favour of the banks. The decision is that the bank's exclusion clause has prevented Ian from being successful in his claim that he was missold the interest rate hedging product. Although the decision is a profound disappointment, and I think it's quite clear it is a profound disappointment and we shouldn't be afraid to admit that, what is quite extraordinary is the impact of the judgment. When one sits and reads the judgment, it is actually a vindication of everything that Bully Banks has been saying for the last 3 years. In terms of the evidence that was given at the hearing, it's quite clear that the judge fully accepted Ian and Jill Parker's version of events, and actually is quite critical of the version of events given by the witnesses for RBS. On 10 separate occasions, there is a statement by the judge that he accepts the evidence presented by Ian Parker, and on nearly 20 occasions there are statements by the judge that he, if you like, disapproves of the conduct of the bank or is unconvinced by the testimony given by the bank's witnesses. The findings of fact by the judge are quite clear. Ian and Jill Parker were missold this product. They were badly advised, they were negligently advised. The judge finds that the salesman was motivated by his own interest to Ian and Jill's detriment, and that the banks were motivated by their own interests. The judgment is critical of numerous aspects of the bank's conduct and critical of the conduct of both the derivatives salesman and the relationship manager. The banks succeed purely because of an exclusion clause. Now, the exclusion clause is part of the bank's standard form documentation, and there's absolutely no question at all, no SME would have been able to negotiate a change to that exclusion clause, and there's also no question that other banks provided similar exclusion clauses in their standard form documentation, and no SME would have been able to obtain funding without entering into similar types of exclusion clause. If the judgment is allowed to stand, it's quite a clear statement that a bank can lie, a bank can misadvise, a bank can pressurize a customer into entering into a product of which the customer had very little knowledge and the bank had all knowledge, and that the bank can escape the consequences of those actions purely because of an exclusion clause. If it is allowed to stand, it tells every bank employee that they can lie, they can misadvise, they can pressurize customers to enter into products that are wholly unsuitable, and they can do it with impunity. That judgment is stating that that is English law. If it is English law, it's not English justice. And certainly I would contest in the strongest terms the correctness of that decision given the findings of fact. One thing that comes clearly from specific paragraphs of the judgment is that under the FCA redress scheme, there is no question that this product should have been torn up into its entirety And serious questions are raised by the fact that the judge has concluded so strongly in Ian and Jill Parker's case on the basis of the facts, and yet the banks, under the FCA redress scheme and the independent advisor, have in essence reached a different conclusion. And that is an issue for the FCA to look at, and it's an issue for RBS to look at, and it's an issue for the independent advisor to look at. The judgment is so clear as to the fact that a missale occurred, to the fact that negligent advice was given, and then is so clear that because there are exclusion clauses contained in the documents which were provided to Ian Parker, they're so clear about that, and that is the reason why this case fails. It's as though the judge recognises that there's an issue here, that English law is not providing justice for SMEs who are totally dependent on the banks and who are the recipients of high-pressure sales techniques of products that are unsuitable. Just to quote a few extracts from the judgment, and all of the statements I now make are quotes from the judgment. I do not accept that Mr. Flack has any sound basis for his written evidence that he is quite confident that Mr. Parker understood how these products work. Mr. Gillard's evidence before me was not always frank and at times evasive. I do not accept the evidence of Mr. Gillard and Mr. Flack that Mr. Gillard made it plain at the start of the meeting that he was not able to give advice or recommend a particular product, nor that he explained clearly how different types of product work. Nor do I accept that Mr. Gillard provided a clear and detailed explanation. I do not accept that Mr. Gillard explained the option of an interest rate cap. I reject the written evidence of Mr. Gillard that at the end of the meeting, Mr. Parker showed a good understanding of all the concepts which I have discussed. Indeed, I do not accept that Mr. Gillard was concerned to ensure Mr. Parker fully understood the nature of the products on offer. He wanted Crestsign to understand them sufficiently to sign up to one of them on terms satisfactory to the banks. He was not concerned to ensure that Crestsign understood the product sufficiently to enable it to judge whether they were objectively suitable or which was the most suitable. His priority was to conclude the deal, benefit the banks financially, and thereby enhance his position with his employer. In sum, the banks did provide negligent advice, but they successfully excluded any duty not to do so. The judgment is clear, it's profoundly disappointing, but it does reaffirm in very clear terms that Ian and Jill Parker were missold this product, and they were missold it through a conscious process of deceit.